Hello and good evening. This is Advocate Rajdeep Lahiri back once again with another short video on the practicality of law. Now today we are going to be speaking something on a very important subject, the subject pertaining to how to effectively draft or finalize a legal opinion. Now there are various types of legal opinion that can be sought by various types of clients. So it could be pertaining to both civil and criminal disputes. It could be pertaining to Negotiable Instruments Act. It could be pertaining to any ongoing case. It could be pertaining to an anticipated filing of any case, both civil and criminal in nature. So keeping that in mind, I'm going to be speaking on certain broad guidelines, which you should keep it in your mind at the time of drafting and finalizing a legal opinion. Okay, so it is divided into various parts, the way I do it. So I'm going to explain the way I do it, and in turn, which you should keep in mind that the way I do it, I've also, confirmed and adhered to the way my seniors were doing when they were formulating or drafting legal opinions. So the first thing which I do is write the name of the querist, which is the individual or the company or the entity which is seeking a legal opinion from you. So we will term that as the querist. So the querist name is there. Then directly we jump into the facts of the present matter, which is the facts in brief you must entail in the legal opinion, at the very preface of the legal opinion, so as to give the reader the knowledge or the concept behind you arriving at the legal opinion, which will be at the very end of the document that you will be preparing. So querist, then we come into the brief facts, should not be more than 10 to 15 lines, and you must entail the entire narrate the entire facts in issue or in question. Thereafter, please mention the documents that you have produced or you have been provided. Write down all the documents. It could be an agreement, it could be other legal opinions, it could be a memorandum of understanding, it could be any case papers for that matter. So write the case number, the details, the plaint or the evidence or the agreement along with the date, the reference number. So it's very important for that to be written down so as to again give the reader the understanding, the basis on which you arrived at the legal opinion, which is again at the end of the document. So once we have the very facts in the front, now we go into the facts in detail, which again should not be more than 5 to 6 bullet pointers, which should correlate to the introductory facts that you have written at the very preface of the document. So these facts should be in chronological order, as has been explained by you, as has been explained to you, and ultimately will be explained by you in this paragraph, where you will be entailing the facts in substance. Then you please come on to the statutes, the rules, policies, authorities that you have referred to for your arrival at the legal opinion in the document. You can write all these sorts of acts, the statutes, any bylaws, or for that matter, even I entail any precedents which I am referring to, and which will cause to be the foundational support supporting the legal opinion which I will be giving for any legal opinion. So it is again giving a very brief idea to the reader of this legal opinion, the brief understanding as to how you've arrived to answering the query that has been raised by the querist. Then we'll come to the issue, which is essentially the question that has been posed to you to give the legal opinion for the issue that has been raised. So the issue will be, I generally pick up the entire question that has been asked by the querist, and I put it over there so as to give again the reader or the poser of this query entailing the entire question, so as to make him or her understand that it's easy for him to understand that the question that you have asked is the very question that I've posed in the legal opinion, and the answer to which will be the second portion, will be the last portion of this legal opinion, which I've named as the legal opinion. So it is basically the question and answer. So the question will be the question that has been posed directly to you. I have a habit of directly copy pasting the question that has been posed, and the next portion is the legal opinion, which is basically the answer to the question that has been posed. So I start by legal opinion, the last portion of it, by saying that based on the documents provided and authorities cited and perused by me, I hereby provide my legal opinion as under. And I once again put a question mark and I put the query, the question raised, and thereafter I proceed to answer it. And by answering it, I go into the law, the provisions of law. I entail the entire provisions of law, which will necessitate me into giving my opinion, because I want the reader to have a very crisp understanding as to how am I arriving at the answer to the question that has been posed. So I put a lot of emphasis on the provisions of law, the bylaws, and thereafter I will even sometimes if the provision of the law is very clear as to that aspect, I have a habit of reproducing that entire provision in that legal opinion in the last portion in italics, so that he has a clear understanding of what it is. Thereafter I proceed into going into the precedents that may be there, and I will put the citation, the proper citation. I will put the party's name. I will also put the case number, and I will put the judge's name and the court, whichever court it is. It could be a lower court, it could be the high court, the supreme court, it could be any tribunal or any quasi-judicial authority, does not matter, as long as it is sufficing the answer to the query that has been posed. The relevant portions, the relevant paras, I have a habit of copy pasting it in italics so as to once again give the reader basic understanding. Please remember that the reader is banking on your legal opinion as to take further action, further proceedings, and this legal opinion will go a long way in his proceedings. May not stand as evidence, but nevertheless, if you make him ride the wrong train, then please, it's, according to me, it's professional delinquency on your part. So while drafting the legal opinion, have a thorough understanding of the facts, have a thorough understanding of the query, the question raised, the question posed to you, and thereafter please have a fundamental, at a very fundamental level, have a good read of the provisions of law that is involved, the statutes that you're referring to. Read on the law involved, the practice involved, and please read on the precedents. Please don't go without any precedent while forming your legal opinion. So that's about it. This is the way, in a very short video, on how to effectively draft and to keep the broad parameters in mind while drafting a legal opinion. Thank you so much for watching this video. Do share, like, if you learned something new. Do post in your questions if you have any on the chat box below, and I will be back with other short videos such as this one. Thank you so much. We will be back once again. Thank you.